Hill in the matter of Tesco Stores Ltd and Stockport Metropolitan Borough Council.
Should I please?
Yes, Mr. Turner.
Your Lordships, I appear for the appellant in this matter, Tesco Stores Ltd. My learned friend Mr. Carter appears for the local authority Stockport, and my learned friend Mr. Edwards, King's Counsel for Lidl. And
you can assume that we've read everything that we need to read. Not absolutely everything, I think, in all instances, but we have read, of course, the basic materials, including the judgment, including the officer's report, including, of course, the skeleton arguments, and some of the background materials as well.
My Lord, I'm grateful. There are three bundles, as the court knows: the core bundle, the supplementary bundle, and authorities bundle. We have handed up, thanks to Mr. Carter, a printed extract of the MPPF as it stood at the date of the decision. The relevant parts are all quoted both in skeletons and in the judgment.
So this is July 21, is it?
It's July 21. But just in case the court wanted to see it.
That's very helpful, thank you. Do we need to have any other version? The most recent being December 24, I think.
My Lord, we can provide them, but it's not necessary, in large part because the relevant paragraph hasn't changed.
It hasn't changed, no. Fine. No, I think this is fine. I don't think we need to have any more versions of the MPPF.
I'm very grateful. My Lords, if I can start just by providing some very brief background, and I'll just traverse the key documents quite swiftly. The policy is before the court and also quoted in the skeleton arguments, but the key paragraphs are 87 and 88 of this version of the MPPF, and it's the sequential test, and in particular paragraph 87, main town centre uses should be located in town centres, then in edge of centre locations, and only if suitable sites are not available or expected to become available for a reasonable period should out of centre sites be considered. The proposal here for a Lidl store at 111 Wellington Road North in Stockport was for an out of centre proposal. So that policy and the equivalent policies in the development plan was engaged. In terms of the facts, I can first of all just note that I think largely the summary provided in my skeleton is agreed with the other parties. I think Mr. Carter was keen to emphasise that the precise status of negotiations at Water Street and Unit 4B of the Peel Centre, which are the two potential alternative sites, was more advanced perhaps than I described it. But
I think we'd be quite interested to know what's actually happened, because in a sense we're reviewing a piece of history, aren't we, in these proceedings, but what has in fact happened on the ground?
As I understand it, well, perhaps...
I mean, what stores have been built or begun since all of this litigation got underway?
If I can help, my Lord, I've taken instructions on that matter for the purposes of the hearing today. As far as Unit 4B is concerned...
Is it useful to have a look at a map to see this? Is the one that we can...
My Lord, I think the map fell by the wayside with
Well, I was wondering,
round 2.
The first planning case without a map.
I mean, we feel more comfortable with maps sometimes.
My Lord, yes, we can provide one. There was one in the High Court bundle we could provide one.
All right, well, fine. Well, let's just have the description first. But I think it would help us all to have a map, an agreed map, to show what's on the ground and where it is, as it were.
Well, if I can take the sites in turn, beginning with Unit 4B at the Appeal Centre.
Yeah.
That was, as I understand it, in an existing retail centre and a town centre location.
Yeah.
At the time of the decision, there was a contractual arrangement between the operators of...
I missed that. There's a what?
There was a contractual arrangement between the operators of that particular unit and Marks and Spencer. There was a requirement for a planning permission to convert the use of that unit from a non-food retail store to a food retail store. That was granted, and the unit is now occupied by Marks and Spencer's and is being operated as a Marks and Spencer's food store.
Right, so it's occupied by Marks and Spencer as a food store. What's the floor space?
Well, I don't have that immediately to hand. I'll take
And
instructions.
maybe that could be agreed as well. Right, so that's the Peel Centre site.
Yeah.
What about Water
Well,
Street?
as far as the Water Street site is concerned, at the time of the decision, there was a contractual arrangement in place between the owners of that site, whom I understand to be an organisation known as Morbain, M-O-R-B-A-I-N,
Yeah.
with Aldi. The site was a former car showroom, and planning permission was sought for the redevelopment of that site as an Aldi store. As I understand it, and on instructions in, I believe, November 2024, the local planning authority resolved to grant planning permission for the redevelopment of that site as an Aldi food store, or as a food store to be occupied by Aldi.
Yeah.
And that permission has not yet been issued, as I understand it on instructions, pending the completion of a planning obligation.
And going back to Unit 4B, you say there's now a contractual arrangement. At the time, there seemed to be something called legals. Was there just discussion, legal negotiation?
But I think Mr. Carter may be able to assist on that, but as I understand it, there were, I think it is referred to, my Lord, rightly as legals, but there were either completed or emerging ongoing contractual negotiations between the owner of the unit and M&S.
But was there a contract in existence so that nobody else could occupy the land?
I don't immediately have the answers to that. I'll take instructions. Maybe Mr. Carter can assist on that point.
Right. Well, it would help to have these basic facts agreed, I think. You're getting some instructions, Mr. Edwards.
That's right, thank you very much. I can assist on one point, my Lord. Sorry,
No, sorry.
right, sorry, I don't have
Instructions
instructions.
within the form. Not in the formal sense, of course.
Not yet.
Dramatic moment.
I was just being handed...
Even for a planning
there was no
Don't get me wrong, Mr. Edwards, it's quite all right.
I was being handed a piece of paper with a floor space, and I simply went past and asked whether that was net floor space or GIA.
No, well, we don't want to rush anybody, but it would help, I think, to have some of these basic things agreed before us. Good. Let's revert to Mr. Tony.
My Lord, perhaps if we agree a short note that just summarises the position both.
Yeah, no, that would be helpful.
Because what Mr. Edwards has said is consistent with my understanding.
Yeah, and with the note, a map just to show the locations, that would help.
Yes.
Thank you.
But the position at the time of the decision, the position now, because in a way it's the time of the decision that's interesting.
Yes, my Lord. We'll make sure that happens later today.
Thank you so much.
I think that's touched on some of the facts. If I just show the court a couple of the documents which are relevant to these potential alternative sites. So at tab 4 of the supplementary bundle, page 81. This is the latest position from the council's external advisors on sequential approach matters, the position immediately before the planning committee, and it sets out there the position on the two sites, Unit 4B and land at Water Street. And as Mr. Edwards explained, Unit 4B is part of the appeal centre and town centre retail location. There was a next store, it was in the process of closing down, and there were, as it was described there, legals with a retail operator, paragraph 2.2, with the deal moving forward and set to conclude in around 8 weeks' time. So that was the position when that report was written, although that was a few months before the committee report. I'll come on to the committee report in a moment.
Right.
Then land at Water Street, as Mr Edwards described, there was an application by Moorbane. Aldi was the proposed occupier. They had reached a deal in principle, and 2.6, it was said that there was a legally binding agreement between Moorbane and Aldi.
Yeah. Right.
So that position is then reflected in the officer's report, which is tab 3 of the supplementary bundle, starting at page 8. But the critical parts, I think we can go straight to page 57. Capitalised heading analysis, and beneath that, the first one, policy principle and retail impacts.
Yeah.
And a summary of the sequential test.
Yes. Could I just before we look at this, just going back a few pages in the report, we have the objections quoted, I think. Is that right?
Yes.
When we read those lengthy passages, are they in fact direct quotations from the objection letters or the representation letters?
Certainly in respect of Tesco, they were quotations. But I haven't done the exercise of going back to other representations that were made, but certainly in respect to Tesco, they were quotations.
I mean, it reads as if they were direct quotes, actually.
Yes.
Could that be checked by somebody? Because it would save us quite a lot of effort if we knew that these were direct quotations of the objections.
We'll check that.
Yeah, thank you. Sorry, I took you out of your path. 57.
So 57,
Yeah.
under the heading sequential approach, at the bottom of that page, so there's a definition of the catchment in which the exercise is being carried out, and then there's a consideration of particular units that are or would be sequentially preferable, and those are assessed for suitability and availability.
And we're really concerned with the two you've mentioned, aren't we?
That's right. So the first three on page 58 are all dismissed on suitability grounds. Over the page on 59, Sainsbury's former site on availability, and then the Knightsbridge site on suitability, and then we're into the two sites. First of all, the Appeal Centre. There's a description of the fact that the planning permission had been granted for the flexible Class E use, which would allow for a food retailer, and then the position repeated that they are currently in legals with a retail operator to occupy Unit 4B, and the deal is moving forward. Then again, the point repeated in the last paragraph there, the council's retail planning advisor subsequently discussed Unit 4B with Peel. The site owners have confirmed to us they are in legals with another food operator for the unit. Accordingly, it is agreed that the unit is not available within a reasonable period for the proposed development.
Yeah.
And then Water Street, planning application from Moorbane is noted. Aldi has confirmed that they've reached a deal in principle for the occupation of the food store and entered into a legally binding agreement to this effect. Aldi state they would relocate from their existing store on Newbridge Lane. And then, given this an agreement at an advanced stage has been entered into between Moorbane and Aldi, and therefore if permission is granted, Aldi will occupy the store/site. It is concluded the site can no longer be considered to be available within a reasonable period for the proposed development.
Yeah.
And as you've heard, planning permission has subsequently been granted, but relatively recently, November last year. Resolved. resolved
to grant,
planning.
yes.
Planning permission not yet granted. There is a resolution to grant planning permission.
Yeah, section 106 pending.
Yes. Then sequential approach conclusions, and there's a reference to the Tesco objections and Aldergate, the case, which we will come to in a moment, and then the summary. I think the next 3 paragraphs, starting as discussed above, all of those points are important. Perhaps if the court could just briefly read those.
Could I just ask you to pause, because there's a detail I'd quite like to pick up at this point. I'm afraid the lazy way to do this, which I put my hands up and say is what I'm doing, is to go to paragraph 15 of the judgment in the court below, which refers to the passage from the Tetra Tech report, and I think that's the. I'm not quite sure which report that is. Is that the most recent? But if the passage quoted there, which goes to the whole question of what might be described as capacity
Yes.
and or impact.
Yes.
And it struck me reading that it might be quite important as a context, because what it seems to be saying, unless I've misread it and taken it out of context, which I may have done, is that there is what might sometimes in ordinary English be described as scope for the Peel Centre and Water Street sites to be developed for food stores and the Lidl site to be developed. In other words, it wasn't either or, it was potentially at least all 3.
Well, my lord, that's impact.
I know, but it's a context, isn't it, for...
Yes.
I mean, these things are not in hermetically sealed compartments. I mean, there is a holism to this kind of assessment, isn't there, in which you can't really practically separate the sequential approach entirely from impact and scope.
Well, my lord, just to break that down, sequential test, binary outcome, have you passed or not passed? If you fail the sequential test, then planning permission should be refused.
Yeah.
That's the starting point. If you pass the sequential test, if you nonetheless have to, if you reach the threshold for assessing impact, you then have to assess the impact.
Yeah, I think I understand that. But just cutting to the chase then, if you look at the passage quoted by the judge at paragraph 15 of her judgment, is that controversial or not?
No longer. No longer.
What does that mean?
Well, in the sense it was controversial in these proceedings, but not. But
right, so it's not. It is now for the purposes of these proceedings. That quoted passage, the substance of that quoted passage, is not in dispute.
No, that's right.
Right.
But
Let me just make a note of that. Thank you. Thank you. Right. Yes, I took you away from the report. Yes.
my lord, just to emphasise as well, of course, that when those assessments are being carried out, of course, the Peel Centre is in the town centre. So the question there is about the impact of the proposed development on retailing within the Peel Centre.
I understand that as well.
Well, I'm grateful. So yes, in terms of retail impact, no significant adverse effect is the conclusion that is now beyond challenge.
Sure.
Yes, it was just at the passage at paragraph page 60. Those four paragraphs beneath sequential approach conclusions, and effectively this is the council's case, and the middle of those paragraphs, what is considered to be very important is that the issue here is availability, not use. Aldergate clearly states the identity of the applicant is not relevant to the scope of sequential test, and the issue is whether other sequentially preferable sites are available for type of retail use proposed. In this case, as Unit 4B and Water Street have been taken up by other operators, they are not quote, available for the type of retail use for which permission is sought. They're not available to Lidl in this case, or in fact to anyone else. And that's the position clearly encapsulated, accepted by the judge as being a lawful approach, and now put by Mr. Carter as being the...
You say that paragraph in particular it represents unlawfulness.
Yes.
Which precise sentence in the paragraph do you say is wrong or unlawful?
If I was to isolate a sentence, it would be...
You don't have to isolate one sentence.
In this case.
Whatever sentence is, in this case.
In this case, as Unit 4B and Wall Street have been taken up by other operators, then they are not available for the type of retail use for which permission is sought.
If there was another store there that had been running for 2 years, that would also be available then, and the fact that somebody else was occupying it, the identity doesn't matter. There's a site there that's available for use of the store, isn't it?
My lord, no, because it's for a proposed food store. If there's already a food store there, then it's not available for a food store, because there's one already there.
Doesn't it also say all within a reasonable time?
Yes, so it may be, so yes. So it may be that if there's an operating food store, but the retailer is intending to close, that would be available for the proposed use.
But if there's one with a contractual commitment for use as a food store shortly, what's the difference between that, it's not available in the sense of it can't be occupied by anybody else for retail use, so that site isn't available because somebody else has got a contractual right to use it. And what's the difference between that and a site which is also leased and is currently being used?
The difference is that the planning permission should be refused for the out-of-centre site until that use comes forward on the sequentially preferable site.
What does comes forward mean?
That it starts on the sequentially preferable
So
site.
available means until the first plastic bag has been sold for 5p.
Available for the use proposed.
You challenged the sentence beginning in this case. What about the next sentence?
Yes, well, yes. So this is that encapsulates the error of misinterpretation. Although, of course, on the facts, I say that's wrong because the second sentence that you identified.
They are not available.
They are because they are available. They're available to Aldi and M&S respectively for exactly this type of use.
So they are not available to Lidl, but they are available to someone else.
Precisely. So put it the other way.
An existing store is available for this use, albeit it's available to somebody else.
Not for the proposal, in the same way as if you wanted to build 10 houses on a field, if there were 10 houses already there, that site is not available for the proposal for 10 houses.
So it turns entirely on whether the use has begun, not whether the land on which it's going to be carried out.
My lord, I would
to that use.
I would suggest that is the correct point, the commencement of the use. But on these facts, I don't need to identify what in law is the correct point, and there may be questions of judgment.
So the critical moment is the commencement of the use.
My lord, that's what I would suggest. But to win in this case, I don't need to show that because we're not in a case where the use had commenced at the particular time.
So just going, I mean, I know we were expecting this note from you, and that's kind, but as of this morning then, are these sites available?
Unit 4B, I think, would not be available if it is trading as an M&S.
Water Street is, because they haven't sold a thing yet.
They haven't sold a thing. It's a car showroom.
Right, so on that basis, as of today, I just want to get this clear, the Peel Centre site is not available,
It's not available if it's trading as an M&S.
but the Water Street site is.
Yes. And there may be a whole series for other sites which are now available that weren't available in 2022 when the decision was made. In other words, if I'm right...
Go back to start again.
Start again.
What's the magic of the commencement of use? Because availability to the non-planner sounds like taken, earmarked, allocated.
Well, it's for the proposed use, so it's the proposal in question. So your proposal is to sell food. That's the use that you're putting it to. So it's only once the use has started that you put it to that use, and it's no longer available for that use. Whilst you have a shed that is ready to take a retail operator, and it can be put to that use, I would say it's still available.
But until they've got a planning permission for retail use for food, it's a car showroom, so it's not available for that use. It's either not available because it hasn't got a planning permission for that use, or if it's got a planning permission, it's not available for that reason, but you say no.
No, because the planning permission question, should it or should not have a planning permission, that's on suitability. So is it suitable for the use? Then you say, well, does it have a planning permission, or would it get a planning permission for that use? So a site may be unsuitable because it's, for example, allocated a development plan for a school, and that would not be suitable for retail use because a planning application for that use would be refused.
Are you going to tell us about how the public interest is served by your interpretation, or does that not feature in your argument?
It absolutely features in.
So you're coming on to that in due course.
Yes, I'm happy to. Shall I?
No, I don't. I think there's a danger of all bombarding.
I'll take it.
That, for my part, I'd be particularly interested to know how you articulate that.
I think for the moment we'll just let you carry on,
Yeah.
Mr. Turney, and see where we get to.
My lord, so that's the officer's report. I'm going to leave it there, but with the caveat that, of course, officers' reports have to be read as a whole, and I'm not trying to apply a gloss by just isolating these paragraphs. But this is a case where, through argument, we have narrowed it down to those paragraphs.
Very helpful.
And I don't think
Thank you.
it's necessary. So, can I then just show the court one more document, which is the final letter of objection from Tesco, tab 2 of the supplementary bundle, page 6. And I won't read it out, but just to emphasise that this really sets out the case which we now pursue, and makes the point, top of page 7, in this situation, the sequentially preferable units have not even been occupied by another retailer. The report merely acknowledges that there are in legals with another food operator for Unit 4B, whilst a legally binding agreement has been entered into between Moorbane and Aldi for a store that does not yet have planning permission for Wall Street. And it explains the sequential test, and then next paragraph, third paragraph down, in the circumstances, sequential test has not been satisfied on the basis that both the Appeals Centre and the Wall Street site are available and are sequentially preferable to the Lidl application site.
And that's quoted, is it, in the report?
It's not, because the earlier representation is, but this is a sort of post officer's report further submission.
I see, but that was before the members.
Yes. This is sort of Tesco's final word on the application before the determination.
Yeah, thank you.
So, my lords, the issue that I say arises here is a relatively short point of interpretation, and if I can frame it as this, where a site is available for the type of retail use proposed, but not available to the applicant for planning permission, is it to be regarded as, quote, available, close quote, for the purposes of the retail sequential test?
That sounded very useful to make a note of, but I couldn't go that fast, I'm sorry.
My lord, I'm sorry, that's my fault.
No, it's not. So just take us through at dictation speed, because I do want to get a note of that.
Where a site is available for the type of retail use proposed,
Yeah.
but not available to the applicant for planning permission, is it to be regarded as, quote, available, close quote, for the purposes of the retail sequential test?
Right. That's the issue, you say.
My lord, yes. Can I pick up the authorities bundle next?
Yes.
My proposal is to address the case law, then to map out my submissions and deal with some of the points against me, and then return to the judgment at the end, since I think that will be an easier way to follow the sequence through.
No, that's fine.
So in the authorities bundle, the first authority is Tesco and Dundee. I don't need to spend much of any time on that case, which I know will be familiar to the court.
Yeah.
That case concerned the sequential test, albeit in slightly different terms in Scottish policy, but the question there was concerned about suitability and the flexibility that had to be shown by an applicant. There are 2 points of importance from the judgment. First of all, about how suitable was addressed, and secondly, about general interpretation. The points about general interpretation, paragraphs 18 and 19 in particular of Lord Reed's judgment, which were well known to the court. The meaning of policy is, the meaning of the words it is a question of law, but there are always going to be questions of application to the facts, well established principle. Then paragraph 21, I just emphasise the fact that where an assessment of suitability is required, there are questions of judgment in the application, and I say, well, that must be the same for available, but then the question whether such provision is concerned with suitability for one purpose or another is not a question of planning judgment. It is a question of textual interpretation, which can only be answered by construing the language used in its context. And I say the same about available.
Yeah.
And then Lord Reed goes on to say, in the present case in particular, the question whether the word suitable in the policies in question means suitable for the development proposed by the applicant or suitable for meeting identified deficiencies in retail provision in the area is not a question which can be answered by the exercise of planning judgment. It is a logically prior question as to the issue to which planning judgment requires to be directed.
Yeah.
My Lords, if I then go to Aldergate, and I come back to a short point in Zurich, which is next in sequence. Aldergate was critical to the way we frame the argument below, and of course it was referred to in the committee report.
Yes.
The facts in Aldergate are summarised at paragraph 4 and following of Mr Justice Ousley's judgment. The short point is that Aldi proposed an out-of-centre food store. It was operating an existing food store in the town centre, and accordingly it did not look to sites within the town centre in carrying out its sequential test, because it said, and the council accepted, that those sites would be unsuitable because Aldi would not trade against Aldi in the same location. The judge found that approach to be wrong, and the analysis is under ground 1, starting at paragraph 34, page 54 of the authorities manual.
Yeah. If it helps you, we've all read this, of course.
I'm very grateful.
Quite a lengthy passage that runs.
Yes.
It's all been sidelined, I think.
Yes, we've sidelined the whole of 34 to 49 because it it reads most easily as a single.
Yeah, so you don't need to read out any of that.
I'm very grateful. Well, in that case, my lords, I will come back to Aldgate once I've just picked up some of the other authorities. And
Right. I mean, if there is a salient passage or passages that you particularly want to stress, you could identify those for us now if you wanted to.
Yes, well, my lord, as the court note, I emphasise in particular paragraph 42.
Yeah.
Before we get there, I hadn't focused on the distinction between suitable and available. Was the judge actually only construing the word suitable, although he makes observations about availability as well, but he was actually only determining suitability, was he?
My lord, yes, because in that case, the town centre sites have been rejected on the grounds of suitability.
Right.
But it's paragraph 42 is the key paragraph, and my learned friends say, well, that's all must be over, sir, because, as my Lord Justice Lewis just said, the question there was suitable. I don't necessarily accept that distinction is right here, because it's at the core of the court's reasoning that both suitability and availability must be construed in the same way. So therefore, the findings will read across both, and that's central to the court's reasoning. But in a sense, it doesn't matter in this court, because we're looking at a High Court judgment. I think the key point is that below, the judge found that paragraph 42 was overturned, but the question really is, was it wrong? And I say paragraph 42 is right, I'll just emphasise it, second sentence onwards, the sequential test in the MPPF is not just one of suitability, it covers availability. Only if suitable sites are not available should out-of-centre sites be considered. A town centre site may be owned by a retailer already to use itself for retailing, who is not going to make it available to another retailer. It is plainly available for retailing, though only to one retailer. That does not mean that another retailer can thus satisfy the sequential test and so go straight to sites outside the town centre. Available cannot mean available to a particular retailer, but must mean available for the type of retail use for which permission is sought. And I say if paragraph 42 of Aldgate is right, then I succeed in this case, because both Unit 4B and Water Street fell within the type of description there. Indeed, the facts were even less extreme than the ones that Mr. Justice Ouseley was postulating, because neither site was actually owned by the retailer at that particular point.
The proposition in the last sentence in paragraph 42, is that one for which there is any prior authority?
The
last sentence of 42, which is in bold in somebody's skeleton. Yours, I think.
My Lord, not directly.
Or in the judgment.
Not directly, but when Tesco and Dundee, when suitability is considered, the question of suitability is being judged by reference to the type of proposal that's before the planning authority. So that precise sentence, I think, is Mr. Justice Ouseley's original proposition.
And presumably it's inherent in your submission that paragraph, that what Mr. Justice Ouseley has in mind was a site owned by a retailer who was proposing to use it itself, but was not actually using it at that stage for the retail use. Because on your submission, if he was using it, then it wouldn't be available, because the key is commencement of the use.
Yes, it would, that precisely. So that's the critical distinction in terms of timing, and that's reflected in what Mr. Justice Ouseley says.
Right.
So that's Aldgate, and I'll come back to some of the passages in making good my submissions. We have also Waterstone before the court, which is tab 5 of the authorities bundle. I put this case in for two purposes. One of them is it refers to Aldgate without any criticism, but importantly, it's concerned with Welsh policy and at paragraph 84, page 114, it was found that Aldergate and other English cases didn't really assist on the facts. So I just put it in for that purpose to show that it's referred to without criticism, although it's not central to the reasoning of the court in Waterstone. But then the other point at paragraph 84 is this. The first few sentences, however, as Mr. Bewley powerfully submitted, suitable in paragraph 10 to 14 must mean suitable for general retail use.
Sorry, which paragraph is it?
Paragraph 84, page 114.
Thank you. Yeah, sorry. Yeah.
So this is suitable in Welsh policy. Suitable must mean suitable for general retail use, because in that paragraph it is applied to plan making as well as decision taking on an application. And Mr. Lewis accepts that in the context of plan making, that is the accepted and only sensible meaning. It must have the same meaning in respect of each of those functions. And it then goes on to say that meaning is clearly not the same as that used in the English case law. But the first two sentences in my submission are important here as well. That's Waterstone. There are 3 other cases on sequential test matters, and I just refer to them briefly. The first one is the Zurich case, tab 2, Mr. Justice Hickenbottom as he then was, and it's just to encapsulate a particular submission that I made. Page 25 of the authorities bundle, paragraph 22.
Yeah.
And it's paragraph 22, Roman 2. The question as to whether the applicant has demonstrated compliance is logically binary, i.e. it is capable of only one of 2 answers, yes or no. Compliance has either been demonstrated or it has not. And that's why I say sequential test is a logically prior pass-fail. If you demonstrate it or not. If you haven't, planning permission should be refused, but ASDA and Leeds need not be refused if other considerations indicate otherwise. A similar point, I don't think actually having reviewed it, it assists to take you to the judgment, but a similar point in Halebank, but in a different sequential test context. Then the final judgment on sequential test is my Lord the Senior President's judgment in Mead, tab 9 of the authorities bundle.
Yeah.
So, as the court knows, there are 2 sequential tests in the NPPF. One of them is about retail and one of them is about flood risk.
Yeah.
The issue in Mead was about the flood risk provisions, and specifically the issues were about the relationship between the PPG, the Planning Practice Guidance, and the NPPF. In this case, there isn't any guidance which, in the PPG, the Planning Practice Guidance, which informs us of what suitable and available means in this context. So
there's no relevant PPG.
No, so so the case obviously has to be seen in that light. Just to briefly touch on the core components of that decision. So, challenge to an inspector's decision, and paragraph 18, page 178, my Lord's judgment. There's a quotation from the inspector's decision, and at 26 of the quotation, reasonably available sites can include ones that have been identified by the planning authority in site allocations or land availability assessments. There are no exclusions relating to sites with planning permission, or that publicly owned land must be formally declared to be surplus. So that's a reference to the PPG. And then again, at the bottom of that page, quoting from paragraph 36 of the decision letter, the last 3 lines, sites do not need to be owned by the applicant, nor are they excluded because of an extant planning permission or resolution to grant. So long as a site is available to be developed, there is no need for further evidence that they are for sale, or in the case of publicly owned land, declared to be surplus and available for purchase. And that was a finding which was found to be lawful, both by Miss Justice Holgate at first instance and in this court. And if I just pick up my Lord's judgment at paragraph 30, and obviously the issue here is about whether the PPG has amended the NPPF, and if so, whether it can lawfully do so.
Yeah.
But at 30, Lord Banner's argument on this ground rests on the proposition that as a matter of law, the guidance for the sequential test in the PPG could not alter the policy in the NPPF by making it more onerous or restrictive than it was in its own terms. And then, like the judge, however, I think the premise here is wrong. As the inspector recognised, and as the judge concluded at 141, the policy and guidance are entirely congruent. The judge made the point well when he said that the PPG is consistent with the open textured language of the NPPF, properly understood. The guidance does not exceed the ambit of the policy. It does what guidance in the PPG can quite legitimately do, which includes explaining a particular policy in the NPPF and how it is meant to operate. So the proposition that I draw from that is that the meaning of available in the PPG, that is to say, available sites may be sites which are not owned by the applicant, and indeed sites which have planning permission and which are owned by somebody else. That is consistent with the word available in the NPPF.
Right.
And then just a couple of other parts of my Lord's reasoning that I say are helpful for this case. At paragraph 44, page 186, in setting up the sequential test, the policy is expressed in very simple terms: to steer new development to areas with the lowest risk of flooding from any source. And of course, I say the sequential test here has the same clear purpose: town centre first. The general thrust of policy is to be seen in the second sentence. Development should not be allocated to places if there are reasonably available sites appropriate for the proposed development in areas with a low risk of flooding, but adds nothing to define or explain the meaning of reasonably available sites. And the third sentence confirms that strategic flood risk assessment will provide the basis, and the fourth, the sequential approach should be used in areas known to be at risk. And the policy at 45 is broad and open textured. And then paragraph 46, absence of definition of reasonably available sites, scope to clarify the concept in the PPG. And then paragraph 47, on the correct interpretation of the policy in 162 of the NPPF and the guidance of the PPG, the latter did not amend the former. The PPG did not contradict or override the NPPF policy for the sequential test. It did not generate a new or different policy. It did not modify the existing policy by introducing into that policy additional requirements or restrictions. It provided practical guidance on the application of the policy as it stood. It articulated the government's thinking of the concept of reasonably available sites by identifying considerations that would be relevant in applying the pre-existing policy in the NPPF. None of this involved amendment to the NPPF. No such amendment was required. So my submission there is that if available in para 162 has the same meaning as available in paragraph 87 of the NPPF before the court, then and the guidance was within the four corners of that phrase, so that available included sites not owned by the applicant and which have planning permission, then the same should apply to available within paragraph 87.
Right.
My Lords, there are three other cases in the bundle, Hopkins, Corbett and Gladman. Mr Carter's skeleton, paragraphs 8 to 12, summarises the principles in those cases, and those are not in issue, so I don't need to take the court to those up. I accept Mr Carter's characterisation of those cases.
There's also a case called Warner's Retail, which I confess I haven't gone back and looked at again. I don't know whether it has any bearing on this case or not.
We didn't think it assisted,
No, fine.
but we can provide a copy of it.
No, there's no need to. I just wondered about that because I have a faint recollection of it, but I'm afraid not a very vivid one.
It's a suitability case,
Right.
a sort of splitting.
It doesn't help on the issue here.
We didn't think it did.
No, fine.
Certainly I didn't think it did.
You've obviously considered that question. Fine. That's all I need to ask you. Thank you.
So if I can just briefly then set out my submissions, which won't, I hope, take too long.
Are you going to express these as numbered points, are you?
I've got seven points, but they might not be hermetically sealed.
No, it's fine. Yes, thank you.
Do you think every little helps?
I was only going to ask that you go at relatively dictation speed, if you would, please. That's all.
I will. The first point is to take the words in context. And in doing so, see that the policy is seeking to direct main town centre uses to town centres and then to edge of centre locations. So that's the context of the phrase that we see in paragraph 87. The second point is that the policy should be understood as being neutral as to the identity of the applicant. And this is the first point at which I say the public interest comes in, my Lord, which is that the policy must be interpreted with an objective view of the public interest rather than from the commercial view of the particular applicant. And that reflects the fact that the planning system operates in the public interest. And is generally not concerned with the identity of the applicant at all. And that point was encapsulated in Aldergate at paragraph 37. And the phrase, which I'll read quickly, paragraph 37, Aldergate, page 55, third sentence, it is the purpose of the planning system to control development, that is, to permit, prevent, encourage, inhibit or limit and condition it, so that the individual private or commercial interest and the broader public interest meet in reconciliation, however uneasily. NPPF cannot therefore be interpreted as requiring suitability and availability simply to be judged from the retailer's or developer's perspective, with a degree of flexibility from the retailer and responsiveness from the authority. So that's that point encapsulated in Aldgate.
Just pause for a second. Yes.
So the third point is the effect of a contrary interpretation to the one that I put forward. In other words, the effect of the council's interpretation of the policy. And the effect of that interpretation is that the outcome will depend on the identity of the applicant for planning permission. And that is because, to put it simply, if Aldi had applied for development at this site, they would have had available to them the Water Street site, and they would have failed the sequential test accordingly. If M&S had applied...
If Aldi applied for development at this site, it would have failed the sequential test
because they had Water Street.
No, they didn't have planning permission and they hadn't commenced use.
But Water Street was suitable.
Yeah, but it wasn't available. Didn't have planning permission.
No,
Nothing had been sold from there.
no, my lord, there was a planning application. It was in principle suitable for the retail use and not suggested otherwise. And it was available to them on the interpretation favoured by Malone & Friends, because they had some sort of contractual arrangement over the site. So if they'd applied for planning permission for this site, they would have failed the sequential test.
Oh, I see.
And the same would be true of M&S. They would have failed the sequential test because the planning authority would have said, no, you've got Unit 4B available to you. And we put this another way round. The consequence of this is that one retailer, Lidl, was entitled to a grant of planning permission at Wellington Road North, whereas at least two other retailers would not have been entitled to that grant of planning permission. And again, returning to Aldgate, that was precisely the mischief that was being explored at paragraphs 39 to 40 of Aldgate.
(39 to 40).
Yes. Page 56 of the authorities manual.
Yeah.
Any alternative, this 39, any alternative approach would reduce the sequential test to one of the individual operator's preference, with the suitability of centre sites and their availability varying from applicant to applicant, each proposing the same broad type or even identical form of development.
I just wonder whether you're turning it around. If Aldi wanted to have two sites, the one they had and this site, then they would have got it, because on their analysis, the first one wasn't available and it wasn't one site. They were having two shops. So you're turning around the Aldi. In the Aldgate example, they didn't want to have two sites, and they said, we would like to have site 2, please, in preference to site 1. But the analogy here with Aldergate would be if Aldi said, we've got one site, but we're going to have another site as well, please.
No, my lord, I don't accept that that's the correct analysis. If Aldi were applying for this site, if they were applying for Wellington Road North, then on the council's analysis of the policy, they would have a site available to them, Water Street.
What happens if they want two sites, though?
Then they will be refused the second one in favour of the sequentially preferable.
No, they want to have two shops.
Well,
They
then,
want to run two shops.
yes, well, potentially, I suppose potentially they could apply for multiple sites, but to say that the sequentially preferable site is not then available to them is false, and it maybe the planning authority would have to deal with it by saying that by refusing the second application on the grounds of sequential preference and dealing with them in turn. I don't think that that sort of situation, if you applied for an in-centre store and an out-of-centre store at the same time, that seems to me, in my submission, to be an easy way to to get through the sequential test, because you would simply apply for planning permission at all available in-centre sites with no intention of ever developing them, so that you can say that none of the in-centre sites are available because you've already applied for planning permission for them, and then promote your out-of-centre site, obtain planning permission and build your out-of-centre and leave the other ones derelict.
It should just be more subtle than they were in Aldergate.
Well, yes, but I mean, the mischief in Aldgate, paragraph 39, spells it out in terms, because the effect the effect of this sort of approach is described halfway down paragraph 39. Any other approach would make nonsense of the sequential test to the advantage of an operator well represented in the area, or one reluctant to compete with certain other retailers, however sensible that reluctance might be commercially. So the bottom line is that if Aldi control the in-centre site that's sequentially preferable, then Lidl may have to do without a planning permission for their out-of-centre location. They may have to. But that's the effect of the test. And then it goes on to say the applicant may not be a retailer or may not have an operator identified. And if we put that in this context, if this was an application which didn't name Lidl as an applicant, then the answer again would be this retail use can go to Unit 4B or to Water Street, sequentially preferable, because it could be taken up by Aldi or taken up by M&S. Then it goes on, Mr. Justice, he explores it, all directions of this, and the final sentence, and were a retailer later signed up, it could require a different sequential test for the same application or a repeated application for the same development at the same site. That is not the intention of the MPPF. So the same would apply if midway through these proposals, Aldi had taken control of the Wellington Road North site. Then the application would have to be determined differently than if it was Lidl promoting the site. And then the point is, again, paragraph 40 continues. And then the last, I think perhaps the last sentence only is worth emphasising.
You're submitting, sorry to interrupt you, but just while you're on this point, you're submitting in effect, if I can put it this way, that the sequential test is operator blind.
Yes.
Sorry, I interrupted you. I apologise.
No, my lord, I was just going to emphasise the last line of paragraph 40 in Aldgate. On the local authorities analysis, Aldi would have got permission for the RSOL site, the site in question, leaving Lidl to contemplate a town centre site now facing greater competition. If Lidl had been the chosen operator for that site, it would have had to consider the town centre sites. It's not how the MPPF is intended to work, so it's the same point expressed in a different way. So the fourth point I make is that suitable and available, those two words, must be approached from the same perspective. And it's notable here that there is no suggestion that anything before paragraph 41 of Aldergate is wrongly decided. But if suitable and available are approached in the same way, it must be necessary to disregard the operator.
Sorry, start that again, I beg your pardon.
If suitable and available
Yeah.
are to be considered in the same way, then in considering available, it must be necessary to disregard the operator and focus only on availability for the type of retail use proposed. And in that context, I say para 42 of Aldergate is obviously right. My fifth point is that the sequential test is intended to have the same meaning and effect in plan making as it is in decision taking. And at the plan making stage, it obviously would not be appropriate to identify where retail needs should be met by reference to individual retailers.
That seems very close to your previous but one point.
It is, but it's taking into context the plan-making function. And for the court's notes, I don't think I need to go through it, but Aldergate paragraph 36 is where Mr. Justice Ousley makes the same point.
Yeah. It's the first of his sequence, I think.
Yes. And then it's the Waterstone para 84 point. My sixth point is that the interpretation of the NPPF in Aldergate, including in paragraph 42, has stood since 2016 until the judgment below, and at no point has the Secretary of State found it necessary to revise the NPPF or issue PPG to contradict what was said at paragraph 42.
So the wording in paragraph 87 has been substantially retained, is it?
It has.
Or
Yes.
precisely retained?
Precisely retained.
Since 2016?
Yes.
You said to issue PPG or change NPPF.
Yes.
Yeah, and you make the point, there's a general point, perhaps I made it in media, I'm not sure quite in what terms now, that where the government sees the need to prevent inconsistency or incoherence in decision making, it has the simple expedient of issuing online guidance, which it can do now if it wants to.
My lord, yes.
If it sees a real problem.
Yes.
Problem is, if they didn't really knew, I mean, it all depends on what it means actually, and in a sense, the trigger will come if we go one way rather than the other way, and the government doesn't like it because it wasn't dealing with availability; it was dealing with suitability, and it's just one of those many things that just hasn't been explored until the facts arise.
Well, my lord, I accept that to a point.
Yeah.
And I recognise that this is a supporting submission
Yeah.
rather than a central submission. But I do say that paragraph 42 of Aldgate was both very clear and also well known in the planning sphere. And if the Secretary of State thought that it went against her policy, then one would expect.
It could have avoided the risk of it being interpreted in the way that you say it should have been interpreted, yeah.
And my seventh and final point is mead. And on mead, I've already made the point, but if the word available in the flood risk sequential test includes a site that is not owned by the applicant and which has planning permission for that use, then the court should proceed on the basis that the same word has the same meaning in the same document, unless there is a clear indication to the contrary.
You haven't said it yet, but is it implicit in your submissions that, insofar as one can draw any parallels between Mead and Aldersgate, they are aligned? Is that what you submit?
My lord, yes. Yes, because available in flood risk sequential test is treated by EEG, this court says lawfully, as being available for the use in question, their residential development, and not being determined by availability to the particular applicant.
I'm just looking at the words of 87. That's where we start and which will end. And what has to be not available are sites. If they're not suitable, then they're ruled out, and suitable is clearly looking at the land use, presumably, to see that that site is suitable for the uses being proposed. But the next bit is looking at sites A that are not available, and B are not expected to become available. And I wonder whether it's necessary to conflate the identity of the owner with the availability of the site. It may become available for a number of reasons. Leases expiring and to be on the market. It may become not available for a number of reasons. They want to turn it into a block of flats or something. But if there is a physical site, and the reason why it can't be released and used by a particular applicant for planning permission is that it so happens that somebody else has got it and is about to use it for that same purpose. I wonder whether that's all that available means there. It's already taken. Well, it doesn't matter who took it, it's taken.
My lord, I say no, because that would necessarily bring into consideration the identity of the applicant. So that would necessarily turn on the applicant.
So to clarify, if we had to clarify 87, what words would you put after available? When it says only if suitable sites are not available, what word would you add after available to make it crystal clear?
Available for the type of retail use proposed.
Irrespective of the identity of the applicant.
Yes.
And would the same qualification be applied after the word available in brackets?
Yes.
You see, I understand the older gate. You can't treat it as not available when you, the applicant for planning permission for site 2, have it at site 1, but you don't want to use it for site 1 because you prefer site 2. I understand that factual scenario, and that's really not defining available, it's defining when it can be, when it's not possible to treat it as not available. But leaving that scenario aside, where you're in a different situation and you're not looking at the choice of the applicant for planning permission, and you're back and looking at the availability of sites, I just wonder, and you'll say no, whether the availability of sites does look at things like, has it got a lease or a contract on it? Has it already opened for business? Is it about to open for business tomorrow with a grand opening? You would say it's still not available. Planning permission hasn't been commenced, or the development hasn't been commenced. And I just wonder whether available, when you're looking at it positively, there could be a range of circumstances indicating when it's available or when it's not available. But you would say no.
So, my lord, on Aldergate, at the start of my lord's question, in Aldergate, the sort of site notionally in question was not the town centre Aldi site, it was other town centre sites, which Aldi said it couldn't trade in because it was next door to its existing Aldi, with Pointless to open next door to its own shop. So it's a slightly different proposition there. But
it didn't want to trade because of its perceived effect on its balance sheet.
So it said that's unsuitable.
Yeah.
It said it's not suitable for me to take this site next to my Aldi because I can't open an Aldi next to an Aldi.
Yeah, and you're saying the same would occur if you're looking at available. If it's not available for this because we don't want to use it for this because it'll be in competition with our own site.
Or because we've contracted to, or someone else has contracted for that site is the better example, is the best parallel. But on the substance of the point, I perfectly accept that there is going to be. The court asked me to sort of identify when a site would cease to be available. If we take the Water Street example, I perfectly accept there's going to be an element of judgment about what stage you're at. So, a rational planning authority may say, well, if we come to determine another application the day before the grand opening of Aldi Water Street, then we can lawfully conclude that that is no longer available for the retail use proposed.
Yeah, and that's nothing to do with the identity of which shop has got it.
No.
It's the fact that that site isn't going to be released for the use in the planning application that you've made because it's been earmarked and is about indeed to be opened.
It's not available for a proposed retail use because it is already in retail use.
No, it's about to become in retail
that's
the point. It's not in retail use. It's about to become. It's 2 months before the grand opening.
So, my lord, that's why I accept that there's going to be an element of planning judgment on those points where one would not expect an overly rigid approach that says on the 18th of February I would refuse planning permission for the outer centre site, but on the 19th of February I would grant it merely because the grand opening is on the morning of the 19th. Mm. So I accept there are elements of planning judgment there, but the question is availability for the use. And if Moorbane, for example, have constructed a food store with a sign saying to let, or even without a sign saying to let, because they've already got a contract to let it, it remains available for that retail use. It is available for the proposed use. And national policy says that that site should come forward first.
Come forward first. One has to be careful. That's not what national policy actually says.
No.
I mean, it's very tempting sometimes, isn't it? Perhaps even in this case, to say the policy means what it says.
Yes.
Not what it doesn't say.
My lord, yes. And
I mean,
the
that's a
phrase
fairly
is wrong.
secure proposition, isn't it?
My lord, yes. And the phrase I used there was the wrong one. But
Yeah, I think one has to be careful.
my lord, yes. And I don't. I'll withdraw that phrase. Can I rephrase the way I put the
Of course, yes.
So the effect of the MPPF is that let me just get it right so I don't fall into the same trap again.
Sorry.
The effect of the MPPF is that a sequential test should be applied to give effect to the second sentence of paragraph 87, which is that main town centre uses should be located in town centres, then in edge of centre locations, and only if ...
Yeah, but you're doing now what perhaps I did in Mead, in the paragraph you showed us, when I went through the 4 sentences in whichever paragraph it was.
My lord, yes. And
And
I say that...
that's what you've just done.
So that's...
Which is, of course, in principle, an entirely legitimate exercise to undertake. The quest for meaning has a beginning and an end. The journey in between will be tortuous or not.
So that, I say, identifies the sequence to go through. And if the position is that there is a site in the town centre which can be developed for the retail use proposed, then it should be developed for that retail use in preference to the out of centre site.
Just to go back, you accepted that there's an element of judgment, and if it's got planning permission and it's about to open, they could say it's not available. So there could end up being 2 sites, the one that's about to open and the town centre. So it's not one, it could be 2. Why isn't an element of judgment to say, well, planning permission they've resolved to grant it, it's subject to a section 106. The 106 is virtually agreed. The only thing that they haven't quite agreed is going to be 2 pelican crosses outside the school or 1, and that'll be solved. It's not a deal breaker. So that site's not available now. Planning permission's been granted, or about to be granted. 106 agreement virtually agreed. We just don't think that's going to be available. So the question is, given that there's going to be 1 unit there, that site isn't available, should there be a second one? And there may be reasons why you don't have a second one, but it wouldn't be because of the sequential test, because there'll have to be 2 then, not 1. It's not a situation of 1 and only 1.
Well, my lord, I say that because that use for which planning permission has been granted or resolved to be granted may never come forward. And indeed, in the example I gave earlier, if that approach was lawful, it would be possible to essentially block the available town centre sites by applying for planning permission for them.
So that's the answer. And
then come back with your out of centre proposal and say all of those are taken up. If you do that, I say if that excludes those town centre sites from being available, then the effect is that you will leave empty the town centre sites and develop the out of centre in preference.
It's a glimpse of a real world reality, which is that things change over time.
Precisely.
You know, on the first night of a particular production, seats may not be easily available. When the run has lasted 3 weeks, you can get in, and you know that's availability, isn't it? And a further glimpse of it is actually seen in the words of the policy itself, or which may become available within a reasonable time. So the temporal element in all this is actually important. We've seen, as you know, in this case, we've seen, haven't we, that circumstances have, as one would have expected, moved on somewhat. That's just a glimpse of the obvious.
I was going to ask you about paragraph 43. Are you going to make any submissions on paragraph 43 which slightly qualifies the sort of iron principle that the identity of the applicant is never relevant? Because it seems to say that sometimes it is.
Yes. So, my lord, yes,
You're going to make.
I wasn't proposing to, but I can certainly address the court on that. So I'll do so. Might I just answer, my lord,
Please focus on the Lord's question.
No, I'll come on. I'll take it.
It was barely a question.
I'll take it in sequence.
Perhaps a contemplation.
I just simply to say that indeed the status of sites availability will change during the course of the determination of a planning application, as has been demonstrated here. And if I can put it bluntly, that's why there's probably so much toing and froing on these sorts of applications, because I think the retail appraisal which you have, which the court has in the bundle, is the fourth appraisal, and that is being driven in partly because of disputes about impacts, but partly because the availability of sites is fluxing.
Yes.
Yeah.
So yes, I accept that, and it does mean that that it's a difficult area, but I say in this case a very simple answer.
Yes. Well, we must ensure that which belongs to local planning authorities stays.
Yes.
Otherwise, we have a planning system that is entirely run by judges, which is not the planning system that is familiar to me.
My lord, yes, and if I can just briefly pick up paragraph 43, and then I'll turn to just address some of the submissions made against me, which we've largely covered during the course of my submissions. But on paragraph 43, this is Mr. Justice Ousley's note of caution, as my lord observes, about instances where identity may matter. The example that I think might be relevant is the hoarding example, hoarding by developers.
Yeah.
So if it could be shown that there's a position where there is no way to overcome the ownership constraints, then one might take a different approach. Although in my submission, that is unlikely to apply simply because the operation of a market, and if somebody is proposing a retail use, and has a good cause to promote it, another operator that doesn't wish to promote the retail use will be outbid on the site, and that's just the operation of the market. Now, there are and have been in the past sensitivities about this, about the land ownership of particular retailers.
Yes.
And I suspect that's what Mr. Justice Ousley had in mind, that there have in past been suggested problems with the planning system as a result of the sequential test.
I mean, is it too simplistic to say that there could be cases where a particular company hoarded a number of sites which, on your interpretation, would still be available? And I come back to my public interest point of that.
Yes, so one might say in those circumstances, I would say that the good reasoning there is that those sites are available, that the sequential test is failed, but there are good reasons to nonetheless grant planning permission, because the only reason that this proposal has not passed the sequential test is because developer A is sitting on his hands. So I'd say that would be a sort of departure case rather than analysing it through the MPPF. The other example he gives is about suitability and about extensions, which logically cause a problem because you can't extend your existing store on a different site. And that's why he's, in my submission, dealing with that there.
That goes back to your judgment, because you said there may be elements of judgment. It seems to me, from the submissions you made, it's an absolute necessity that planning permission has been granted. And there may be judgments as to, is it about to be implemented, is it about to be opened, and so on. But until the point at which at least planning permission has been granted, as opposed to the commencement of use, it will be available for use. Not least because planning permission might be granted for retail use for that site. So the box closes potentially after planning permission is granted, and certainly after the use commences. At the latter stage, use it is no longer available. At an earlier stage, between the grant of planning permission and the actual commencement, you seem to accept that that's an element of judgment, but at no time before the grant of planning permission can it ever be said to be not available, because it could be available to someone for planning permission, for retail use.
Well, yes, I don't. Whether planning permission is an important point, I think, would depend on the particular fact. So, if we take, for example, Unit 4B, planning permission had already been granted for a flexible use that would include a food retail use, but the site was still occupied by Next as a clothes retailer, but they intended to vacate. So that was the position. That site was available. Planning permission was already in place. Next were about to leave. And the reason it was found to be not available was simply because, however, another food retailer, and I just hesitate a bit before we say this is Marks and Spencer, because I think the history is slightly more complex. It is now Marks and Spencer. Another retailer has control over that site.
And has planning permission for it, and once they clear Next out, will be using it. Is that capable, is this within your judgment category, that there are some things where the use has not yet commenced, retail food use has not yet commenced, but nonetheless the council could say it's not available?
Well, my lord, I think if the facts had been that M&S were stripping out the unit and putting their chiller cabinets in, then I can see that the council may say that whilst it's available for the use today, within the next 2 weeks, it will not be available for the use because it would have been taken up. And there will be an element of judgment there. I struggle to deal with the, obviously there will be difficult cases, but my submission is that these are easy cases.
Yes, but I can't see the difference between that in principle and the situation where you've got a resolution to grant planning permission and you're just waiting to finalise the 106. But both sides have every confidence and every interest in finalising the 106. But why that isn't the same sort of question of judgment as to availability, because it still will be a retailer and the identity is just irrelevant. What's relevant is the stage that's been reached in being able to release that site on the market for food retail.
My lord, if I put it this way, and this is just to work an example, I'm not suggesting this is what's happened, but just to work an example. In the present case, Lidl could buy the Water Street site tomorrow, and they could then open the Wellington Road site and keep the Water Street site as a car showroom, which
would run counter to the purpose of the policy.
Precisely.
Yeah.
All right. So you've made your 7 submissions.
I have, my lord. I think if I just briefly check my note on the submissions that were made against me, very, very briefly, and I was going to return to the judgment. The thrust of Mr. Carter's submission is that those 2 sites, Water Street and Unit 4B, are not available to anyone. It's paragraph 14 of his submissions and paragraph 20 of his submissions. And I say that that's the wrong question. It's whether it's available for the retailer. It's not whether it's available to anyone other than Aldi or M&S respectively.
Do you think these are points that could be made in reply?
My lord, I'm very happy to.
If you're working through the skeleton argument, might it actually save your time and energy if you heard the submissions actually made to the court?
My lord, I'm grateful. In terms of the judgment, I don't mean any disrespect to the judge, but I don't think I need to explore it in detail because in essence I've dealt with the substance. If I just go to the judgment at paragraph 38. So ground one reasoning is 38 to 47.
Yeah.
If I'm to sort of isolate the error in the judgment, I say it's at paragraph 43. The judge here relies on the words in brackets, or expected to become available. She says the words in brackets are a key aid to construction. The words or expected to become available within a reasonable period, when given their natural and ordinary meaning, point to some possibility of any unidentified applicant having the opportunity to secure occupation of a site within a reasonable time frame. And I say that's wrong. It is about availability for the retail use proposed, and it may be that a particular applicant, because they have a poor commercial relationship with the landowner, or for whatever reason, is not in practice going to be able to bring that proposal forward. The planning system still prefers that site to the out-of-centre site. And the reference to the commercial reality at paragraph 44 in my submission means that it becomes operator specific, the test becomes operator specific, and sites are wrongly excluded that could otherwise have been considered available. So in my submission, in fact, although paragraphs 45 to 46, the judge makes the point that the council was straining to fall within the terms of Aldergate, and I accept they've obviously thought about this very carefully. They in fact were going flat against Aldergate by making their decision on Lidl at Wellington Road North turn on the fact that it was Aldi and M&S who had some degree of control over the sequentially preferable sites. So it became all about the applicants and all about the identities rather than neutral to the identities.
In paragraph 43 of the judgment, this goes back to the point that Lord Justice Lewis and I were both hovering around in my case, my vague way about the words in brackets. And is she saying there that available means different things in each case? Is that what she's saying? Is she saying that available in brackets means available to anybody, whereas available before the first time whereas available means something different? Is that what she's saying?
My lord, I don't know. To be frank, in my submission, the reason that the judge sees the availability within a reasonable period as giving rise to this question of anybody,
non-applicant specific, not specific applicant.
Not specific is because well, going back to my lord, the senior president's point, which is that availability may flux. I think I suspect that's what she has in mind. But where she goes wrong is identifying by reference to availability to any applicant, when applicants will necessarily be excluded because of particular commercial positions.
The worry I've got at the moment is, if I just read available, I would have thought it meant something like committed or taken up, because that's what it sounds like. The problem is that there is one scenario in the universe when a very naughty developer wants to build a huge out-of-centre store, and he buys up a small little area in the town centre, and either, as bluntly as Audrey did, we're not going to open it there because it's being competition, or by saying we want 2 planning permissions, please. We want a little local store and we want the big out-of-town centre, and everyone secretly suspects within 6 months the town centre will be closed and we'll all be trekking off in our SUVs to get bags and bags of shopping from the town centre. And I'm very worried that because somebody might do something naughty, and we're worried about that, we are changing the words of the plan of the policy to not have it meaning what it normally means in most scenarios, but redefining it to stop that naughty scenario happening, but also not in a way that was intended, because the opening words of the previous ones dealing with plans expect there to be a range of sites available and a range of shops available, and it's not the one first and then we'll see how it goes. It could be 2, it could be 3. That's the problem that I've got at the moment, just so that you know what I'm worried about. Not that you can do anything about it, but...
No, well, I suspect I can't. But my lord, on that question, I say simply that if one has in mind that available must be a reference to the proposed use.
Yeah.
Because that's what the policy is about. It's about plan making, it's about decision taking, it's not about identity of applicants, it's about the proposed use. Available for the proposed use, then those sorts of questions start to be answered in a very different way.
Yeah, and it'll automatically deal with the naughty scenarios, I've called it, as well as the normal scenarios. Yeah, okay.
Unless I can insist further.
John?
No.
No. Thank you very much, Mr. Chairman. Thank you. Mr. Carter.
Please, Your Lordships. If it assists, the outline of my submissions is going to be to deal with some very short points in relation to the facts, some of which have arisen during the course of this morning. Secondly, to set out my submissions on the general approach to policy interpretation, because although they are not controversial, my submission is going to be that the appellant's approach overlooks those very important points of approach. And then thirdly, to develop my submissions about how those general points of law on interpreting policy relate to the specific policy that we have to interpret in this case.
Right.
My Lord, I ought to perhaps say at the outset that learning from Mr. Turney's formulation of the issue that he gave this morning and then re-gave at dictation speed, has the complication within it that it uses the word available twice. And in the first sense, in the first time the word is used available, where a site is available for a type of retail, etc. In my submission, there is a danger that that formulation begs the question that your lordships have to determine, because my submission is going to be that the 2 sequentially preferable sites were simply not available when the policy is properly interpreted. My Lords, to deal very briefly with the factual matters, the first respondent will of course cooperate in the note that your lordships have asked for this morning. The second point is one matter of clarification that might not matter, but I ought to make it. The Water Street site is a cleared site. It is not the car showroom does not exist. It's been demolished and taken away.
When was it cleared, actually?
I don't know the...
Had it been cleared at the time?
I'm now told it never was a car showroom. It's never been there. It's a vacant site.
So it is a vacant site that had planning permission for use for a car showroom.
Yes.
They don't buy cars in Stockport.
So what was its previous use, actually?
A mixture of employment and industrial uses, I understand.
Right. But it's now cleared,
Lord, yes.
and when it was actually cleared, you're not sure?
No.
Right.
My Lord, next point, my Lord, the Senior President asked whether the officers' reports, when reporting the objections, was giving them as direct quotes.
Oh, yes.
I'm instructed that they are.
Okay.
My Lord, the Senior President also raised paragraph 15 of the judgment below,
Yeah.
which is on page 54 in tab 7 of the core bundle.
Thank you.
My Lords, that is it drawn from the last of the reports that the first respondents, retail consultants, gave to the authority, and it's within the supplementary bundle. It's the only one of the retail reports that is in the bundles.
Yeah.
It's at tab 4 of the supplementary bundle. Your Lordships will see at page 78 It bears the date the 27th of July 2022, so this is the final report. And perhaps one small matter that might usefully be clarified. Your Lordships will have seen reference to the authority having reports from Tetra Tech and Alder King. It's the same person that wrote them. He moved practices at some point during the course of the application, but it was the same gentleman who was advising the authority all the way through. And the passage that the judge sets out in paragraph 15 of her judgment is a direct quotation from paragraph 4.7 of this final report on page 89 of the supplementary bundle. I don't have anything to say about it, my Lord. I just wanted to make your Lordships aware of where that had been derived from.
Page 89.
Page 89 of the supplementary bundle, my Lord, paragraph 4.7 of the report.
Okay, thank you. Thank you very much.
And then my final point on the facts, my Lords, is to reinforce that the appellant has never disputed the first respondent's position that the two sequentially preferable sites weren't available to the second respondent or to any other party outside the negotiations and the agreements that were underway and that had been made. And Millennium Mr. Attorney put it this morning that they were available because they were available to Marks and Spencer and Aldi. In fact, at the time the decision was made by the council, I'm not sure that they knew that it was Marks and Spencer who were interested in Unit 4B. There was discussions that there was in-legals between the landowner and an operator, but I don't think the authority knew that it was M&S at that stage, but nothing perhaps turns on that.
Yes, the expression in legals.
To a sense, we're all illegal. That's what we've been doing for the last 45 years.
A ubiquitous concept.
It is explained to some degree in the officer's report in that it was thought that heads of terms had been agreed, solicitors had been instructed on both sides and substantial costs had been incurred in the way to getting to an agreement, but there was no finally concluded agreement, but the indications were that it was on the way.
Right.
My Lord, those are the observations I want to make in relation to factual matters.
Right.
Turning to my second main head, general points in relation to policy interpretation.
Yeah.
In my submission, it is important not to lose sight of the fact that the court's task here is to interpret paragraph 87 of the July 2021 version of the framework. That is the statement of policy. It's not the task to interpret paragraph 42 of Mr. Justice Ousley's decision in Aldergate. And that's why I've drawn attention, and I'll deal with these quickly, my Lords, because they're not in dispute. Lord Carnwath's judgment in Hopkin Holmes, don't ask your Lordships to turn it up, but it's Authorities Bundle, page 76, paragraphs 23, 24 and 26, make the points that interpreting the words of policy needs to be undertaken in a way that guards against over-legalisation in the planning process. Paragraph 24 makes the point that some policy words may be expressed in broad terms that don't lend themselves to elaboration. And my submission, that's particularly apposite here. And paragraph 26, one has to keep interpretation of policy and application of policy as distinct concepts, which again is more important here in my submission. There's more detail in relation to those general propositions that I seek to draw from my Lord the Senior President's judgment in Corbett and Cornwall County Council. Paragraph 19, again I don't ask the court to turn it up given that these are not controversial. Page 140 of the Authorities Bundle. We don't interpret policy using the same linguistic rigour as we do for a statute or a contract. One should not be drawn into construing and parsing policy exhaustively, and we should avoid unduly complex or strict interpretations. And policies will often be flexible enough to allow for the exercise of planning judgment in the various circumstances in which they will need to be applied. That, in my submission, is crucially important here, and Millennium Mr. Attorney's conceded that in the course of his submissions this morning. And thirdly, and equally important in this case in my submission, one should not interpret planning policy by putting a gloss on the words of the policy. And in my submission that would include adding words that aren't there. We shouldn't interpret policy by substituting words, because that leads to what my Lord the Senior President, drawing from earlier authorities, leads us to founder on the rock of substitution. And we shouldn't try and do it by paraphrase.
Yeah, I think I referred once to the seduction of paraphrase, which ought to be properly attributed, I think, to Lord Justice Laws, lest it be attributed only to me. I forget which case that was.
My Lord, I've drawn attention to two other authorities that deal with this general point. There is Mr. Justice Holgate, as he then was, his judgment in Gladman versus the Secretary of State, paragraph 99, Authorities Bundle, page 166.
Sorry, which case was that?
It's the case of Gladman Developments Limited versus the Secretary of State.
Yeah.
That his Lordship's observations at paragraph 99 that policy flexibility means that policies shouldn't be interpreted through the lens or prism of a disappointed participant in a planning decision, because the words have to be applied to a wide variety of circumstances, not just a specific factual matrix. And finally, that is a point which Mr. Justice Ouseley himself made in Aldergate, and it is perhaps worth turning that up. Authorities Bundle, page 58. Paragraph 48 of the judgment. At the end of the paragraph, policy interpretations arising from litigation may be context and argument specific and not intended as substitutes for the test at issue for all cases and contexts. The good sense of the planning consequences of any given interpretation may be a guide to its correctness. Again, that's an important pointer in my submission to the appropriate approach and result in this case. And in a nutshell, my Lords, my submission is that the appellants have taken one part of one passage in the Aldergate judgment and inappropriately sought to apply it to a different context. Bearing in mind that Aldergate was about suitability, not availability. My Lords, I ought to perhaps deal at this stage with what my learned friend has said this morning about Mead and the Waterstone case. So far as Mead is concerned, as the court is well aware, that case was dealing with the relationship of the PPG to the NPPF and the status of the PPG and the status of the NPPF.
Yeah.
And whether the PPG can diverge from the framework, and generally exploring the relationship between the two documents. This case doesn't raise those kinds of issues. This appeal doesn't raise those kinds of issues. And in fact, in my submission, if anything, the assistance to be drawn from Mead is assistance that assists my case.
Right. Because
Here we have, in what was paragraph 87 of the framework, what I would submit is a broad policy statement using ordinary words of English. And this, for whatever reason, the Secretary of State has not chosen to elaborate upon them or even to depart from it in the PPG. He and now she have left us all to grapple with the word available as it appears in paragraph 87.
Well, to the extent that any grappling is necessary.
To the extent that any grappling is necessary. Well, some is clean well because we're all here, but to the,
well,
to the extent...
we're certainly here. I mean, that's an existential verity that we can all rely on. But how much grappling is necessary is another question.
And my Lord, the assistance I would draw from Mead is to be found at my Lord the Senior President's judgment at paragraph 45 on page 186 of the Authorities Bundle, in the final tab of the Authorities Bundle, where my Lord refers to the relevant paragraph of the NPPF in that case, reasonably available sites, connoted an elastic concept, not defined or limited by any other text in the framework, nor accompanied by any criteria. It leaves for decision makers a range of evaluative judgment in ascertaining whether a particular site is or is not reasonably available. that applies with equal force to the words in the framework that this court is grappling with on this occasion in my submission, as my learned friend for the appellant has accepted this morning. As for Waterstone, my lords, in my submission there is nothing to be derived of assistance from the Waterstone case, precisely because of the issue that was actually being dealt with. And if I could invite your lordships to briefly turn it up, because it's a passage that's not sidelined, for which apologies for my part in that failure. But it's tab 5 of the authorities bundle, page 92 is where the judgment begins. Your lordships will see that the very opening paragraph, paragraph 1 of the judgment on paragraph 94, makes it clear that the key question was whether the substance of planning policy in Wales was substantively different from that in England. One side said it was, the other said it wasn't, and the court found that it was, and that's why they found that Aldergate and the other authorities in the English and Scottish concept were of no assistance to the issue that they had to determine. So it's unsurprising that this court didn't say anything of detail in relation to Aldergate, because that case's relevance was discounted on a much higher level basis. So in my submission, nothing in this case is to be derived from the Waterstone case. Lords, I'll obviously deal with Aldergate in the course of my detailed submissions in relation to the specifics that the court is faced with here, and that's what I turn to. And my lord, I have on my numbering 9 points to make. They are all but one are relatively short.
Right.
My first point is...
Right, again, if you could go at a speed that we can... Right.
I will, my lord. My first point is the appellant is trying to use a policy interpretation which arose in one context and apply part of the reasoning that led to it in an inappropriate way in a very different context. And my other points seek to make that general proposition good. Secondly, and turning to Aldergate itself, in tab 3 of the authorities bundle.
This is your point 2.
It is my point 2, my lord. Aldergate dealt with a very different issue from that here, which arose because the parties were in dispute as to what the Supreme Court had meant in Tesco and Dundee, as to what the development proposed by the applicant meant in that case. And my lords, your lordships can see that from paragraph 34 of Aldergate on page 54 of the authorities bundle. Halfway through that paragraph, the District Council's advocate submitted that the authority had correctly understood and applied Tesco because it had focused on the commercial requirements of the proposed operator. So that's how the issue arose. That's why the issue is one entitled to take into account an operator's commercial requirements, or indeed, in truth, in that case, preferences.
Yeah.
And so Aldergate is dealing with a very different situation. That's my second point. My third point is, at no stage in the consideration of its application, at no stage in its consideration of this application, did the first respondent take the second respondent's identity into account, either when formulating or assessing the sequential testing that had been carried out. As the judge concluded in the court below, at paragraph 45 of her judgment, page 68 of the core bundle, the first respondent was at pains, her words, to disregard the identity of the second respondent.
That's 45.
Judgment paragraph 45, page 68 of the core bundle, my lord, yes. And unlike continuing my point 3, unlike in Aldergate, the issue here is not whether the sequential testing was influenced by either the second respondent's identity or their commercial requirements or their preferences when deciding how to construct and conduct the sequential testing. The issue here is the far more straightforward one of whether sequentially preferable sites, suitable sequentially preferable sites, were available at all. That was the issue that the first respondent was grappling with.
It's not the identity of the operator, it's the willingness to use the site. And as it happened, the reason why the operator was not willing to use the site, I suppose you would say, is because the operator had one that it preferred.
In Aldergate, yes, my lord. In this case, there's no question of the second respondent's willingness coming into play. It was their ability to access the site.
That's what you would say. It's the difference between willingness and ability.
Yes. And then my fourth point, my lords, is to grapple with some of the detailed reasoning in Aldergate, starting from the general proposition that what Mr. Justice Ouseley held in that case was that suitable and available, he was actually dealing with suitability, but he goes on to deal with both, meant suitable and available for the broad type of development proposed in the application by approximate size, type and range of goods. That can be seen at paragraph 35 of the judgment on page 55 of the authorities bundle, where his lordship sets out in plain terms his conclusion before going on to give his more detailed reasons for that. And his lordship gave 4 reasons for that. My lords, I'm not going to read the paragraphs out because your lordships have indicated that this has all been read, so I'll take it as swiftly as I properly can. The first reason is given at paragraph 36, where his lordship construes the framework without considering the Tesco case and concludes that the approach should be the same for plan making and decision taking. I don't dissent from that, I don't dispute that, and no part of my case depends on having a different approach to the concept of availability for plan making or decision taking. And my case in my submission would not lead to any inconsistency of approach between plan making and decision taking. The second reason his lordship gave was in paragraph 37, which is that the framework requires development to go to town centre sites first, and it's by doing that it's seeking to reconcile developers' interests and other private individuals' interests and the public interest, which would be undermined by allowing a developer to decide the terms of the sequential testing exercise. Again, it's no part of my case to dispute that proposition or to say that it's wrong, but it's no part of the first respondent's approach took those preferences into account in this case. And if part of the purpose, an important policy aim of the sequential test, is to ensure that development for town centre uses is directed to town centres, as it is, and then edge of centre sites before being permitted in out of centre sites, if a site is not available, if an applicant can't access that site, then refusing planning permission will not direct the proposed development to that site, and that important policy aim just wouldn't be achieved. And I do ask your lordships to bear in mind what those real-world consequences would be, because they might inform the proper approach to interpreting the policy.
Just pause for a second. Just repeat that submission, would you?
Yes, my lords. If I accept that an important purpose of the sequential test is to seek to direct town centre uses towards town centres, then edge of centre, and only after that to out of centre sites. But if a site is not actually in the real world available to an applicant, no public interest is actually served by refusing the planning application, because that development can't find its way to that sequentially preferable site.
In retail policy, as it now is in the NPPF, retail development policy, does one find reference to competition and choice? Which used to feature in government policy for retail development.
There's a reference to it in paragraph 90B in the extracts that have been handed in this morning. The Lord.
Yeah, so
It's relevant when it comes to impact assessment.
well, it's broader, isn't it? When assessing applications for retail development outside town centres, reading from the beginning of 90.
Yes, and then it goes on to talk about impact assessment in detail, my lord. So,
Well, it does, but it's the impact of the proposal on town centre vitality and viability, including local consumer choice and trade in the town centre and the wider retail catchment,
yes,
as applicable to the scale and nature of the scheme. So, consumer choice is still an element of
yes,
government policy.
yes.
Yeah.
My lord, returning to Mr Justice Ousley's reasoning in Aldergate, his third point is to be found at paragraph 38, where, again, hopefully appropriately summarising, his lordship said in essence that there was nothing in the framework that suggests that developers' preferences can dictate the terms of the sequential testing exercise. That's perhaps another way of putting points that had been earlier made. And paragraph 39 identifies what the adverse consequences of taking the developer-led approach would be, and paragraph 40 illustrated the difficulties for the authorities case because they accepted that the sequential test would have been different if it was a different applicant in that case, and that paragraph 41, the situation wasn't redeemed by imposing a personal condition in that case because that would simply have reinforced the error of approach. Again, nothing in that reasoning conflicts with my client's approach in this case, because there was nothing in their approach which used the applicant's preferences or commercial interests to determine the outcome of the sequential testing. Now, it's in that context, that overarching context, that the passage in paragraph 42 appears, and the conclusion that a site which was owned by a retailer already, who, in Mr Justice Ousley's words, is not going to make it available to another retailer, he concludes is still available for the broad type of retail development. Now, that point was not the focus of his lordship's deliberations in that case because he was dealing with suitability, not availability. And so I do submit that that part of paragraph 42 is not part of the ratio in Aldergate. It was overtur because it wasn't necessary to deal with that issue to answer the specific question in that case. But in my submission, to get to the nub of it, and my fifth point, available is an ordinary English word that has no technical meaning. It is not elaborated upon by the Secretary of State in the framework or the PPG. It has to be applied in a wide variety of factual circumstances. No gloss should be applied to it in trying to interpret it. And my submission is, hopefully this is not too simplistic, a site which has been taken up by another operator is not available in any real sense of the word. It's been taken up. And in Aldergate, the issue was what should the site be available for? Here, the question is whether it's available at all, not what's it available for. And so my sixth point is,
I suppose you would say it's no longer available. It was available at one stage, but once it's been taken up, it ceases to be available.
yes, and I'm a learned friend, Mr. Turney, for the appellant has accepted that whether that has happened or not involves planning judgment by the authority. That simply serves to demonstrate that this is an elastic concept that one has to reach a judgment about what the outcome should be. It's not a word that can be strictly applied and its results predicted in advance for all factual circumstances. And my sixth point is that the difficulties in the appellant's approach are illustrated by the submissions that have been made this morning, because initially, in response to my Lord Justice Lewis, my learned friend said that availability ended when the use commenced. And my Lord Justice Lewis's sale of the first 5p bag. Well, in my submission, one doesn't have to stop and think for very long to realise that that is not a sensible proposition, because on that logic, and this is why my learned friend had to row back on it later on, if a planning committee met to consider another application the day before the store opened, as initially put, that newly built store would be an available site that was sequentially preferable, which in my submission is not correct. Once my learned friend recognised that, he accepted that evaluative judgment comes in, and that if it was seen that the store was well on its way to opening, you might conclude that it's not available. Well, in that case, by making that concession, my learned friend has, I would submit, made my case for me, that once there is evaluative judgment comes in, it's for the local planning authority. And it's never been the appellant's case to say that the authority's approach was irrational, merely that it had, not merely, but it was a different proposition that they had misunderstood the meaning of the policy wording. And if there is that element of grey area, how far back would you go before you decided that a property wasn't available? Does it mean when the roof goes on? Does it mean when the first excavations are carried out? Does it mean when the site is bought? Does it mean when the coming soon sign goes up? All those, that just serves to illustrate that there is an evaluative judgment that has to be reached by the authority, and it's a matter for them. My seventh point is, if I need to go this far, that the example postulated by Mr. Justice Easley in paragraph 42 of Aldergate, that a site which is owned by a retailer and won't be made available is a site that is available, is a conclusion that is wrong in my submission. I'm not contending that the decision in the case was wrong, merely that that part of the reasoning in paragraph 42 is not correct.
Let's be clear, precisely which bit do you say is wrong?
It's the paragraph, my lord.
42, yes.
42.
Is there a particular part that's wrong? Or is it all
Yes,
wrong?
it's probably starting at the very bottom of page 56, the last two words. A town centre site may be owned by a retailer already to use itself for retailing, who is not going to make it available to another retailer. It is plainly available for retailing, though only to one retailer. In my submission, that example would be a site that is not, or it is a site that an authority could conclude was not truly available. And indeed, his lordship goes so far as to say, when you read the plain words, that a site which is not going to be made available is available.
Just the third and fourth sentences of that paragraph.
Lord, yes, because the rest of the paragraph is saying what the consequences would be of adopting the interpretation that was being rejected, but that's not the actual reasoning.
When they're doing this, how would it work? If they're saying that unit B or whatever it was, is not available because somebody is going to use it, therefore we can treat this as an acceptable site. They've still got to assess impact, but I suppose that would depend on the catchment area and things like that, wouldn't it?
Yes.
And if they were all within the catchment area, they would still have to assess impact. So you'd still have to look at the effect of having two stores rather than one in that situation.
Lord, yes. I'm going to say a little bit more about the two stores
okay.
example in one of my later points, if I may.
Okay.
During the course of the argument this morning, my Lord Justice Lewis raised the question of whether the appellant's position was distinguishable from one where an existing store was open and operating and the landowner was using it for that purpose, whether that site, on Mr Justice Ousley's logic, would be an available site. And the appellant sought to say, no, it wouldn't be, because this is about testing proposals for development rather than reusing an existing store. That claims justification in my submission breaks down as soon as one has in mind a situation which is either, just thinking of two examples, if the proposal is for a store possibly on the same footprint but reconfigured to suit a different operator's approach, or a modest but material extension. If the extension example is probably the better one, my lords. If a proposal was being made for, let's take the example of a 1,200 square metre store, and the existing unit on the existing site was 1,000 square metres, that justification that was proffered this morning for saying that that wouldn't be a sequentially preferable available site breaks down. That was my 7th point. My 8th point responds to the argument that my learned friend made along the lines of, well, what if the application had been made at Wellington Road North by Aldi or Marks and Spencer? Now, I'm a little bit nervous about dealing with Marks and Spencer as the example for the reason I gave a little while ago, that I'm not clear that it was known that Marks and Spencer's were the intended occupier of Unit 4B at the time. So I'm just going to deal with the Aldi example, if I may. I don't think it makes any difference. And the argument is put that if the first respondent was confronted by an application made by Aldi, it would have said that the Water Street site was available because it was available to it, and that would be said to be an illustration of the authority wanting, on the one hand, to take operator identity into account, and on the other, not doing it. My answer to that is twofold. Firstly, it would be appropriate for the authority to potentially refuse an application in those sort of circumstances if it was clear that what the operator was trying to do was, to put it colloquially, game the system. If this was a situation where there was some risk that the authority was aware of, that a developer was trying to game the system or inappropriately evade the sequential test, it must, in my submission, be appropriate for the authority to take that into account when determining what the appropriate result would be. And secondly, there is the point that, again, my Lord Justice Lewis raised about the two applications. Well, what if Aldi wanted to have a second site? My learned friend almost went so far as to say, well, you'd have to refuse the one for the out-of-centre site whilst the first in-centre site was permitted and developed. But that would seem to connote there are, in my submission, two problems with that approach. The first is it would seem to imply that an operator couldn't make two planning applications at the same time. It might be that an operator, and it might be Aldi or might be a more abstract example, the operator might say, we're applying for 2 grants of planning permission because we think there is capacity for 2 stores and there would be no significant adverse impact from 2 stores. And the second reason why I say that interpretation or that approach is problematic is because it comes very close, if not actually comes very close to reintroducing a concept of having to prove need for out-of-centre retail, which used to be an aspect of English retail planning policy but hasn't been for some time, although I can't tell your lordships precisely when it stopped being, but it was, but it isn't now. 2009, my learned friend Mr. Edwards tells me, thank you.
Yeah. I mean, it is for that reason that I couched my question earlier in terms of scope or capacity.
Yes.
And impact.
Yes.
Or lack of it.
And I would respectfully agree with the proposition that your lordship postulated, that one has to, although sequential and impact testing are conceptually different and importantly separate parts of an assessment, one must not lose sight of the overall whole exercise that is being thought about, which is to protect the vitality and viability of town centres, ultimately. And important though it is, the sequential test is not everything, because there is the important matter of the impact test to consider as well. So for those reasons, in my submission, the Aldi and Aldi scenario, if I can call it that, doesn't assist my learned friend. And in any event, perhaps this is the most important point on this point in my submission, if the approach that I'm advocating might throw up the odd hard case, that is not a reason for attributing a meaning to the word available that it cannot properly bear in my submission.
And if you go back to willingness and ableness, Aldi are able to use the one site. It may not be willing to use the one site. If it's willing to use both sites, it's different.
Yes.
But if it is a different set of circumstances, somebody who wasn't Aldi, they might be very willing to use that site, but they wouldn't be able to because they can't get access to it. So if availability equals able to be used, the circumstances may, in some circumstances, involve looking at the reasons why a particular person says it's not able. It may not be identity, but the identity may feed into the reasons why it's not able to use it.
My lord, yes. And as a very, very long stop, to deal with what, again, my Lord Justice Lewis referred to as the naughty developer
So
scenario.
I wasn't putting anyone in the room, by the way, or anyone at all.
If there was a developer who was trying to construct a situation where he or she could evade the sequential test, and there was reason to believe that was going on, but the sequential test had otherwise been carried out properly, as a long stop, it's perfectly appropriate in my submission for the local planning authority to consider using either or both of planning conditions and a planning obligation to ensure that the out-of-centre development did not go ahead before the in-centre proposal was up and running. It would be perfectly appropriate, and in my submission one can readily envisage that planning obligation would pass the 3 tests for a planning obligation that sought to regulate the sequencing of events between an in-centre and out-of-centre, so that to avoid the situation where the operator could cherry-pick the out-of-centre permission and leave an in-centre site languishing in need of regeneration or whatever the facts of the case might be. That's not, in my submission, that is not to try and use the get-out-of-jail-free card that was unsuccessfully deployed by the authority in Aldergate, because I'm not advocating that as a way of making good defects in a sequential test. It's a way of guarding against potential consequences. But bottom line in my submission is that there is always a potential for any system of rules and policy to be gamed by anybody, and there's only so much anybody can do about it. The situation's always in flux. It might be the case that an authority and a developer conducted between them an absolutely impeccable sequential and impact testing, granted the planning permission, and the very next day a new sequentially preferable site manifested itself that no one could have foreseen. I think events change over time, and there's only so much the planning system can do to cope with that. So that's my 8th point, my lords. My 9th point and final point is to respond to the points that my learned friend Mr. Turney makes in paragraph 32 of his skeleton, 4 sub-points which appear at call bundle pages 27 and 28. And I can group these. His first point at subparagraph A is to say that suitability and availability have a sensible relationship. I accept that, I don't dispute that, but they are separate concepts. And it's perfectly foreseeable to have a situation where a site might be suitable for a broad type of retail, but not available for it. Similarly, the other way around, a site might be available, but not suitable. So they are related, but they're not the same concepts. And then I can take his learned friend's points B, C and D together, balancing the rights of competing interests, the approach I'm advocating would be the antithesis of the purpose of the framework, and then building on that in paragraph 39 of Aldergate. I don't dispute any of those propositions, but in my submission they miss the point in this appeal, which is simply whether the sites were truly available, not what they were available for. My Lords, those are my submissions in seeking to persuade the court that the judge below was right for the reasons that she gave. Her conclusion was the correct one in my submission, and I invite the court to dismiss the appeal. And unless I can assist any further, those are my submissions.
Thank you.
Do you have any comments on paragraph 43 and 44 of the judgment?
Only that they to some degree support my proposition, which has been accepted this morning, my Lord, that there is a degree of evaluative judgment that comes into play. This can't be an absolutely cast iron rule, because Mr Justice usually does accept that there might be circumstances.
Sorry, I meant 43 of this judgment.
Oh, 43 of this, I'm sorry.
I mean, 40, I can see why you say 43 of Aldergate supports you. Anything you want to say about 43 and 44 of this judgment? Page 67.
My Lord, in relation to paragraph 43, in my submission, the judge below was not seeking to say that available means different things outside the brackets as compared to within the brackets. What she was driving at there is to contrast the situation with what Mr Justice Ouseley said would be the case, because Mr Justice Ouseley's formulation of a site that is owned by a landowner and is not going to be made available to another retailer ignores the fact that policy asks you to think whether a site is expected to become available within a reasonable period, as well as whether it is available now at the time of the decision. That is how I read what the judge below was dealing with at paragraph 43. And in paragraph 44 is a pithy distillation of what I submitted to the judge below and what I've submitted to your lordships this morning. That in essence this appeal boils down to the straightforward point that a site that's been taken up isn't available. So, my Lord, that's what I would say about those two paragraphs.
Thank you.
Lords, those are my submissions.
Thank you very much. Mr Edwards, maybe that you'd rather start at 2 o'clock.
Yes, I would, my Lord. That's acceptable to the court.
Yes, thank you. Right, we'll come back then at 2 o'clock.
Do you want Brian to pay one?